the mighty and resilient Merrimack River, carving through the communities of our great region. My name is Linda Lorden, proud president of Merrimack County Savings Bank, and like the river that serves as our namesake, we're a constant yet ever-changing presence. Because to us, it's bigger than banking. It's about powering communities and putting people first. It's about knowing where you came from and where you're going. That's Merrimack style. Visit us at themerrimack.com.
History as it happens, August 1st, 2024. Supreme Court versus Founders.
Without presidential immunity from criminal prosecution, there can be no presidency as we know it.
Could you be more precise as to the source of this immunity?
And he orders the military or orders someone to assassinate him. Is that within his official acts that for which he can get immunity?
It would depend on the hypothetical, but we can see that could well be an official act.
They could, and why?
This court has never recognized absolute criminal immunity for any public official.
American presidents, even former presidents, are now above the law when performing official acts. The Supreme Court ruled 6-3 in favor of Donald Trump as he fights charges related to his efforts to overturn the 2020 election and the January 6th riot. The court did not clearly define what an official act is. The vagueness, in the words of historian Sean Wilentz, gives any president carte blanche to commit crimes up to and including assassination and treason, with virtual impunity from criminal prosecution. The Dred Scott of our time? That's next as we report History as it happens, a podcast from the Washington Times. I'm Martin DeCaro.
We've had term limits for presidents of the United States for nearly 75 years after the Truman administration. And I believe we should have term limits for Supreme Court justices of the United States as well.
The Roberts Court has been the most politicized, the most intellectually and legally bankrupt, and perhaps even the most corrupt court that we've ever seen in American history. You really do have to go back to Dred Scott to see a decision that was so politically arrived at. It's not the first time that this happened, but this decision is the greatest reconstruction of the American presidency in American history, or judicial reconstruction at any rate, that we've ever seen.
We will hear argument this morning in case 23-939, Trump versus United States. Mr. Sauer.
Mr. Chief Justice, and may it please the court. Without presidential immunity from criminal prosecution...
In April, the Supreme Court heard arguments in Trump v. United States. The former president's attorney, D. John Sauer, made a case for absolute immunity from criminal prosecution for official acts. Now, as we know, Trump was indicted on charges of conspiring to defraud the United States, conspiring to obstruct an official proceeding, and violating a post-Civil War Reconstruction-era civil rights statute that makes it a crime to conspire to violate rights that are guaranteed by the Constitution, in this case, the right to vote. This was all, of course, related to Trump's attempt to overturn the 2020 election. The give and take between the justices and Sauer often turned into, at least this is what it sounded like to me, far-fetched hypotheticals as the justices asked Trump's attorney, what is an official act and what isn't? Here's an exchange with Justice Sotomayor.
If the president decides that his rival is a corrupt person and he orders the military or orders someone to assassinate him, is that within his official acts that for which he can get immunity?
It would depend on the hypothetical, but we can see that could well be an official act.
They could, and why? Because he's doing it for personal reasons. He's not doing it like President Obama is alleged to have done it, to protect the country from a terrorist. He's doing it for personal gain. And isn't that the nature of the allegations here? That he's not doing these acts in furtherance of an official responsibility. He's doing it for personal gain.
The characterization is that there's a series of official acts that were done for an unlawful...
No, because immunity says even if you did it for personal gain, we won't hold you responsible. How could that be?
That's an extremely strong doctrine in this court's case law in cases like Fitzgerald.
Well, we go back to Justice Thomas's question, which was, where does that come from? there are amici here who tell us that the founders actually talked about whether to grant immunity to the president. And in fact, they had state constitutions that granted some criminal immunity to governors. And yet they didn't take it up.
At one point, Sauer said Benjamin Franklin at the Constitutional Convention made a case for immunity. When it came to the charges in this case, Sauer said Trump should be immune when it comes to the slates of fake electors, because in his view, the former president was legally challenging the 2020 election, so those alternate electors might have been needed at some point. At least that's what his reasoning sounded like to this non-lawyer. We'll get into more of these exchanges with my guest in a moment. The 6-3 ruling, with the 3 liberal justices dissenting, granted Trump most of what he wanted, but it left to the trial judge in D.C. to work out the difference between official and private acts, which will give prosecutors a chance to show their evidence against Trump as they presented in court for inclusion in his now long-delayed trial. In an essay for the New York Review of Books, Princeton historian Sean Wilentz writes, "The majority opinion in Trump v. United States, the most sweeping judicial reconstruction of the American presidency in history, secures the monumental historic disgrace of the John Roberts Court. Since last winter, the Supreme Court has intervened directly in the 2024 presidential campaign by effectively shielding Donald Trump from being tried on major federal charges before the November election. No previous court has protected a political candidate in this way." Wilentz goes on to say, "The Roberts Court has descended to a level of shame reserved until now for the Roger B. Taney Court that decided the case of Dred Scott v. Sanford in 1857. Just as that court majority sought to suppress the anti-slavery Republican Party and to help permanently secure the slave power's control over American law and government, so the Roberts Court majority has sought, thus far successfully, to protect Trump from prosecution and to secure radical changes in American law friendly to MAGA authoritarianism. The Supreme Court," Wilentz says, "has once again willfully placed itself at the center of a presidential election on which the future of American democracy turns." I will include a link to his essay along with the Supreme Court's written decision in my weekly newsletter. You can sign up at historyasithappens.com or find History as It Happens on Substack. Now, here's the understatement of the year. The news has been crazy lately. The presidential election drama has overshadowed pretty much everything else, including this ruling. But these political headlines are going to fade. It's all very intense now, but I promise you it will fade. This ruling on presidential immunity will endure, potentially for years to come. President Biden, who will soon exit the stage himself, tried to redirect our attention by announcing proposed changes to the Supreme Court, including term limits of 18 years.
I have great respect for our institutions and the separation of powers laid out in our Constitution. But what's happening now is not consistent with that doctrine of separation of powers. Extremism is undermining the public confidence in the court's decisions.
Biden's proposals were denounced by conservatives. Sean Wilentz is one of the great historians in our country, the author of The Rise of American Democracy and The Age of Reagan, among many books. Sean Wilentz, welcome back.
Great to be here, Mark.
We're going to talk about your essay in the New York Review of Books about a story that has somehow gotten swallowed up, a story of historic import, this ruling in the Trump versus United States case. But briefly first, the historic import of President Biden's decision, I think it was a belated decision, but a decision nonetheless, to withdraw from the presidential race at this late stage. This just doesn't happen very often in recent American history.
Well, as you say, Martin, it's unusual. I think it's unprecedented in this case. But we're living in very strange times. So, I mean, the only thing that's predictable is the unpredictable. So I wasn't shocked by it. Considering all that he managed to accomplish during his first term, he did something really quite amazing. I mean, look, other presidents, Lyndon Johnson, for example, is a good example of the most recent case where a sitting president has pulled himself out of a re-election campaign. But Johnson did it because he was becoming extremely unpopular because of his policies. His foreign policies seemed to be running us into the muck, into the mire. Whereas Biden's had a very successful presidency by any measure. So what's odd is to see a successful president withdraw. It had to do, of course, with not simply age, but with his, his physical condition as it showed up. We don't have presidents that last this long. We haven't. Yeah. So it's a new world. We're catching up with it. It was a peculiar, I think, concatenation of circumstances in his case, because I think he came into the presidency, I don't know this for the case, but I think he said it, intending to be a one-term president, to hand it off to a younger person, but that things change. And I can understand why things changed in his mind, because the world changed. I mean, Putin invades Ukraine. Somebody has to pull NATO together. Somebody has to be able to come up with a foreign policy. Well, Biden this is his strength. This is what he does. And this is what he did. And across the board, I think there were a number of crises that arose that played to his strengths and that I think he thought he could do. Getting as much done as he did with such thin margins in the Congress. I mean, there aren't that many people who could have pulled that off. So I think he thought that he should keep going because no one else could do it. Unfortunately for him, it led him to overestimate how well he could run in his condition.
So despite the domestic policy legislative achievements that you're pointing to, of course, for instance, the editors of the National Review might disagree with you whether those are achievements or not.
Sure.
Yeah, but,
sure.
But despite that, he was an unpopular incumbent.
Yes. Yes.
Foreign policy, I mean, we know that he was in trouble with more liberal people, more liberal members of the Democratic Party, if you will, over his support of Israel in Gaza. Not to go down every single point here, but he was an unpopular incumbent. But I guess most incumbents are unpopular these days.
Yeah. Well, nobody's popular these days. I mean, both of the people running for president are unpopular. That has to do with another aspect of our politics. But you're right. I mean, he had great achievements, but he wasn't being, appreciated for them. And I think he thought perhaps he could turn that around. But the polls showed that he couldn't. So there it is.
One more about Biden before we get to SCOTUS. In your book, The Rise of American Democracy, in the 19th century, we had a whole bunch of one-term presidents, basically between Andrew Jackson and Abraham Lincoln. Everyone was a one-termer, kicked out often by their own party. That was crazy stuff.
Yeah. Well, it bespoke something of the instability of the politics of the time. It was also, parties were not quite the same as they became. So it was the idea of the presumption of being a two-term president really wasn't there in quite the same degree. So
I'll just say that today, presidential campaigns take 2 years. There's a need for unity. You get less of the rough and tumble politics of those years, or even more recent times when we had open conventions prior to the 1970s.
Yes.
Parties need to show that they're behind one person who then needs to raise hundreds of millions of dollars to run for the White House.
I know. This is one of the things that actually makes this current situation somewhat refreshing. I mean, it takes the French 90 days to elect a government. Why does it have to take us so long? Why do we have to spend all this much money? I mean, maybe it's a good idea to have it be so short. Yeah. But the fact is, look, we don't have parties in the way we used to. And so you have these individuals raising their own parties unto themselves. There's both volatility and stability at the same time in different proportions.
Yeah, the hollowing out of the parties places so much emphasis on the personality of the person running for the White House.
Correct.
So, all right. SCOTUS, I've been following and reading and sharing in my weekly newsletter, by the way, all of your essays in the New York Review of Books.
Thank you. Good.
I subscribe to that publication primarily to keep up on all of your essays, prodigious writing.
I'll have to pass that along to my editors. They'll be happy to hear it.
So you are calling this the Dred Scott of our time. I'll quote directly from the first paragraph here. It secures the Trump versus United States ruling by the John Roberts Court. Secures its monumental historic disgrace. Is it really that bad, Sean?
Yes. I mean, the Roberts Court has been the most politicized, the most intellectually and legally bankrupt, and perhaps even the most corrupt court that we've ever seen in American history. You really do have to go back to Dred Scott to see a decision that was so politically arrived at. It's not the first time that's this happened, but this decision is the greatest reconstruction of the American presidency in American history, or judicial reconstruction at any rate, that we've ever seen. And deleterious, I think. It gives the president, basically sets the president above the criminal law. They talk about presumption of immunity. In fact, they're basically saying that with regard to official acts, that the president, should have immunity from criminal prosecution. This essentially establishes the president as a kind of quasi-monarch. And this is not what the American government has been, the basis of American government has been since the framing.
So I do want to remind our listeners what the Dred Scott case was all about, but you also make a point about how this ruling fits into the current court's, originalism or textualist. But this is not originalism. I mean, I think that's the thing about the originalist idea. They just dispose of it when it's convenient.
Exactly. And it's a cover, really, for judicial activism. And when they want to do judicial activism one way, they'll do it originally. And if they don't, they won't. And in this case, it's extraordinary because, look, you don't have to be an originalist to believe that precedent and history count in understanding how to interpret the law, how to interpret the Constitution. It's not a question of originalism versus, nothing. It's a matter of how you go about using history. This is completely without historical basis. They invented an entire category of immunity out of thin air. And what's really disturbing about it, though, Martin, I think, is the underlying principle. And the underlying principle is this. It is in the public interest for the president to do whatever he wants. They equate that, but saying that the president has to be forceful, has to be energetic in order to do the public business, in order to do his job. Right? That's equating the public interest with an unshackled presidency. This, to me, is the essence of authoritarianism. To equate the public interest with the power of one person, this is not America, as I understand it, and certainly not what the framers are talking about. I can say that as an historian.
As you know, I'm careful about using terms like fascism and authoritarianism, but one of your most trenchant observations in this essay really resonated with me, and I highlighted it here. You say the decision by the Roberts Court weighs the necessity of broad executive authority as more important than the public interest. Indeed, it equates the public interest with the need to immunize the president from criminal prosecution so that the president can do whatever he thinks he needs to do. This is, you say, the essence of authoritarianism.
Right.
I don't think you're being hyperbolic there.
No, I'm trying to be exact. This is not an epithet. In my case, authoritarian, when I'm saying this, I'm not throwing epithets around. It's a textbook definition, and that's what they've done. Let me put it this way. That is what that is the reasoning behind it. If you read the decisions, that is the underlying theory of this. And it's why they had to do it out of thin air, because there's nothing at all to justify this on historical or constitutional grounds.
You say Justice Taney, this is the Dred Scott case, was the original originalist. We'll do the encyclopedia version here, just in the interest of time, for folks who may not be totally aware of what happened there. Why was Dred Scott such a terrible opinion, and why was Taney the original originalist?
Well, the case was political dynamite. Dred Scott, who had been enslaved, was a slave, and his wife Harriet actually, were claiming that they were free because of their residence in Illinois and in the Wisconsin Territory, both of which were free. And so the question that came before the court was, in part, could Dred Scott actually sue for his freedom at the federal level? But also, as Taney took it, it went to the heart of the politics of the 1850s. And those politics were geared to the Republican Party's idea that the Congress could restrain the expansion of slavery. And what the Dred Scott decision did was really two big things. First, it declared that blacks, African Americans, were not and had never been citizens of the United States. And then secondly, it claimed the Congress had no power whatsoever to do anything regarding the institution of slavery, including excluding it from the territories. Now, this was an extraordinary decision. Why? Because for a lot of reasons. One is it declared an entire political party unconstitutional, which is to say the Republican Party. What it stood for, it said, no, that is unconstitutional. Now, Lincoln basically said, look, we'll obey this, but this is not settled law. And they ran anyway. And it was his election, in fact, that helped undo Dred Scott. Right? So it was extraordinary at that level. But it was also extraordinary for the, what shall we call it, the arrogance. This is the originalism part. Taney claimed that on the basis of his understanding of the original meaning of the framers and of the Constitution, that blacks were not citizens and that property in human beings was constitutionally protected absolutely. Both of those things were manifestly erroneous. as Abraham Lincoln above all, but as the dissenting justices in the case pointed out, this is just ridiculous. It was bad history covering for a radical decision. And that's really what the court has been about, in my view. But what makes this particular decision is just the sweep with which it's gone about rewriting the Constitution of the United States, which is something that Tony tried to do as well.
You know, I'm not a historian or a lawyer. I listened to the hearing. I come into this thinking I have some idea and some common sense about what's right and wrong. And then I listen to the oral arguments and I'm astonished. And maybe I say to myself, maybe I'm the one who doesn't know what the hell he's talking about here.
Well, what astonished you most about the oral arguments? I don't know the interviewer, but I'm just curious.
No, so Trump's attorney, D. John Sauer, he was quizzed by Sotomayor and Kagan. What about assassinations? Does the president have a right to do that? Or Kagan about the case itself. What about the slates of fake electors? Is that something the president's allowed to do as an official act?
We have taken the position that that is official.
That's official?
Yes.
Why would that be official?
Because the organization of alternate slates of electors is based on, for example, the historical example of President Grant is something that was done pursuant to and ancillary and preparatory to the exercise of the core recommendation clause power. So when President Trump
couldn't he have taken this action just in the status of a candidate?
The fact that he could have done so doesn't demonstrate that he did do so in this case. And based on the allegations, we think it's clear he did not, that this was done in an official capacity.
The defendant asked the Arizona House Speaker to call the legislature into session to hold a hearing based on their claims of election fraud.
Absolutely an official act for the president to communicate with state officials on a matter of enormous federal interest and concern, attempting to defend the integrity of a federal election, to communicate with state officials and urge them to view what he views as their job under state law and federal law. That's an official act.
Well, attempting to defend the integrity of the election, I mean, that's the defense. The allegation is that he was attempting to overthrow an election.
And then you hear the conservative justices, as you say in your essay, and you predicted this would happen, kind of helping him along almost.
Yeah. I mean, they took refuge in a particular case, which is Nixon v. Fitzgerald, which had to do with immunizing the president over civil matters.
Yeah. Civil litigation.
You can't sue the president for something, or somebody who was president for something he did, because, you can be sued for almost anything. The burdens of proof are really rather low in terms of getting you file a suit, you don't need a grand jury. Right. Well, for its reasoning, because it had nothing else to go on, the court, the majority of the court took refuge and used that as its benchmark for understanding why it could do what it was doing.
That's pretty thin gruel to base your case on. Another
Yes.
thing that I wanted to ask you about, talking about astonishment here. D. John Sauer, Trump's attorney, kept mentioning Marbury versus Madison in his defense of the absolute immunity claim. Not partial immunity, absolute immunity for official acts.
The executive vesting clause does not include only executive powers laid out explicitly therein, but encompasses all the powers that were originally understood to be included therein. And Marbury against Madison itself provides strong evidence this kind of immunity, a broad principle of immunity that protects the president's official acts from scrutiny, direct sitting in judgment, so to speak, of the Article III courts. That matches the original understanding of the executive.
So how exactly would we determine what an official act is?
I point the court to two cases for that. Obviously, Fitzgerald against Nixon.
Did Marbury versus Madison bestow immunity on the presidency?
That had nothing to do with immunity. You can tease and twist and turn it any way you want. But no, what Marbury v. Madison did above all was to establish independence of the judicial branch, including the Supreme Court, keeping it independent from politics. Marshall was Chief Justice Marshall, who issued the decision, was really very concerned about as he put it in a letter, actually, to Timothy Pickering, which I quote in my piece, that party politics or politics would come and take over the court. He was very concerned about the politicization of the judicial system. That's what Marbury was about. It was a very complicated decision where he kind of threaded the needle between what the Jeffersonians are up to and what the Federalists are trying to do. But he tried to establish the independence of the court, and he did so pretty well, very shrewdly. This case shows the absolute politicization of the court. Again, much as Dred Scott did. Dred Scott, until now, had been the primary example of how you could go wrong in the ways that Chief Justice Marshall feared, Trump v. U.S. is right there with it.
Seems to me the court was grappling with two big questions. What is the difference between official acts and private acts? And then, even if a president is acting under his official capacities, can something still be considered illegal? I thought of like the secret bombing of Cambodia by Richard Nixon.
We're not talking so much about that. I mean, yes, there have been things in terms of foreign policy where you have to talk about the range of presidential authority. But look, it's very simple. There are a few areas in which the Constitution gives the president very specific powers, exclusive power, the power of the pardon, the power to pick his own officers.
Veto legislation.
Veto legislation, exactly. So you can't pass laws which are going to inhibit him being able to do that, right? Those are the core things. No one has really, argued about it. What this court did was to invent the idea that there are official acts that are immune. And this is stretching the idea, I think, as Justice Sotomayor said, this is stretching the idea of core responsibilities beyond recognition. And as you say, or as people have said, what is an official act? You can make anything into an official act. You can make, murdering your spouse into an official act if you thought it was going to be for the good of the country. A speeding ticket could be an official act if you had to get to where you were going really, really fast. Well, that's a trivial example. But you know what I'm saying.
Yeah. In the oral argument, sorry to interject, Sean, we can use a concrete example. Justice Roberts asked about bribery. Sauer, Trump's attorney, was arguing, well, if the president is indicted for corruption, we have to expunge from the indictment official acts. And Roberts said, well, then that means we don't know why he's being charged with bribery because, and I guess the example he used was you're appointing somebody to be the ambassador of a country and you accept a bribe from that. I mean, this is insanity.
It's not, accepting the bribe isn't an official act, but appointing an ambassador is certainly within the official responsibilities of the president. So how does your official acts or the official acts boundary come into play when it's going to be official, assuming that the president is innocent? But the whole question is whether he's going to be found innocent or guilty.
Again, I think Brewster and Johnson do address that, or very persuasively at least, in a slightly different context. Brewster and Johnson say the indictment has to be expunged of all the immune official acts. So there has to be determination what's official, what's not official.
Well, you expunge the official. You say, okay, we're prosecuting you because you accepted $1 million. They're supposed to not say what it's for because the what's for part is within the president's official duties?
There has to be, we would say, independent source of evidence for that.
Well, it is insanity. And the other thing that's insane was Sauer's argument that you could, in fact, the president could be held responsible for crimes, but only if he was already impeached and removed from office, right? So now what does that do? Well, it completely undoes the impeachment clause of the Constitution of the United States, which has nothing to do with criminal punishments. The whole point about impeachment is that it's not about criminal punishments. It's a political act. It's removing somebody from office. The idea that you would link criminal prosecution with impeachment is, again, rewriting the Constitution beyond all recognition. Now, to give the court its credit, where credit is due, it did not buy that argument. That argument it did not buy. But it still leaves the president with, as I say, quasi-monarchical powers.
From the majority opinion, at least with respect to the president's exercise of his core constitutional powers, this immunity must be absolute. As for his remaining official actions, he is also entitled to immunity. At the current stage of proceedings, in this case, however, we, the majority, need not and do not decide whether that immunity must be absolute or instead whether a presumptive immunity is sufficient. So they kind of wiggled out of coming down definitively on one side or the other. I guess it's kind of a vague ruling. So what happens now?
In its vagueness, it is carte blanche. I mean, it didn't come out and say absolute immunity. The absolute immunity question that they tied to the core means that if you are bribed about making an appointment, right? If bribery is there, you are immune from that if absolute immunity is the case.
We'll wrap up, but one more question about a historical point that was raised during the oral arguments. Trump's lawyer defended the fake elector scheme by saying it's an official act. He cited President Grant, who sent the army, I guess, down to the South in 1876 to settle that election in favor of Rutherford B. Hayes. I see you rolling your eyes.
Come on. Look, I mean, the comparison between the election of 1876 and the election of 2020 is so specious as to boggle the mind.
President Grant sending federal troops to Louisiana and Mississippi in 1876 to make sure that the Republican electors got certified in those two cases, which delivered the election to Rutherford B. Hayes. The notion that it's completely implausible, I think, just can't be supported based on the face of this indictment or even
knowing that the slate is fake. Knowing that the slate is fake, that they weren't actually elected, that they weren't certified by the state. He knows all those things.
The indictment itself alleges, I dispute that characterization. The indictment affixes the word label to the so-called fraudulent electors. It affixes the word fraudulent, but that's a complete mischaracterization. On the face of the indictment, it appears that there was no deceit about who had emerged from the relevant state conventions, and this was being done as an alternative basis.
I mean, 1876, there was indeed a great deal. We were coming to the end of Reconstruction. It was there were federal troops already deployed in parts of the South. They've been deployed there for a long time. There were a couple of states where they still existed. I mean, it was a completely different situation in the aftermath of the Civil War. So, look, this is, again, risible. But yet, the majority on the court took it all very seriously.
I find that this story is, well, I mean, the last 3 weeks have been bananas, right? But this is going to last. Supreme Court rulings, they endure. Yeah, it seems to have been entirely swallowed up, understandably, by all the news. But I don't know. I'm having trouble reconciling myself with that reality. I think this needs more attention. Well, I'm trying to give it attention here.
I'm glad you're doing so, Martin. I mean, yes, I mean, I can't imagine this being overturned until we have another criminal president. The only time you can imagine it even coming up. So it is indeed. It is long-lasting. It has changed the character of the American government, American presidency. It is an open invitation to MAGA authoritarianism. Now, that's not a textbook thing, but it is really very much there. The entire thrust of, for example, Project 2025 is towards increasing the powers of the president, giving him total control over the executive branch, that one office, unitary executive theory, and all the rest of it. It goes hand in glove with that. And is a kind of, paving the way. And this again goes back to 20. Insofar as Dred Scott was trying to pave the way to giving the slavocracy, absolute power within the American government, what we're seeing here is the court paving the way for a kind of MAGA authoritarianism. And it's very difficult to see it in any other way.
Two things I'd love to see happen in my lifetime. A bipartisan consensus about reducing the power of the presidency and making it a co-equal branch with Congress again, and a bipartisan consensus around Supreme Court reform. Right now, there is no bipartisan consensus to do anything like that. Expanding the Supreme Court, I mean, why would the side that's benefiting now want to do that? And of course, the side that wants, Democrats in this case, who talk about doing this, expand the court. Well, what happens if, at the wrong time, the wrong justices retire or drop dead? You can... You have a 15-member court with 14 conservatives on it, so...
But there are lots of other ways, though. People keep going to packing the court as the way to do it. There's lots of other things that the Congress can do. By the way, the Congress has a great deal of power under the Constitution over the court, including deciding what cases it takes. I mean, that's in the Constitution. So, the idea that this separation of powers precludes this is nonsense. That said, there's a great deal that the Congress could do. Term limits, for one thing. I mean, you don't have to be, this doesn't have to be a lifetime appointment. That's not in the Constitution. There's no reason why you can't do that. Just beginning with that. In fact, there are groups out there that are talking about lots and lots of ways in which you can reform the court in ways that won't, be, used by one party against the other. Term limits is not a particular, that's an age thing. It's an actuarial table thing. But long before we get to court reform, you have to think about getting through this election. And this election is going to decide, whether we go in that direction or not.
What was FDR's plan to pack the court? They had to undergo eyesight checks or something?
He would call them the 9 old men. I mean, basically the court was cutting down a lot of his New Deal legislation, and he was frustrated at it, and he made a terrible mistake. And it cost him dearly in the 1938 midterm elections. And, he got his wings clipped. Even FDR could make mistakes.
FDR, the master politician of his generation. The court-packing scheme, not his best moments. Sean Wilentz, we thank you for returning to the podcast again. Make sure you sign up for my newsletter at historyasithappens.com, or you can find History As It Happens on Substack. New episodes every Tuesday and Thursday. Newsletter every Friday. This is a podcast from the Washington Times.